Good morning, friends. Namaskar, Adab, and Sasriyakal. This is my 263rd video, and this will be covering how land records had to be retained or maintained by the executives ever since the Britishers were in power or they left. Now, what has been happening by the executives for the last 75 years? You'll be surprised. We people who are living in these cantonments are basically treated like slaves in these cantonments. The executives, with such admonishments, make their replies or affidavits in the honorable courts, which show nothing affects the or concerns these executives. This kind of an attitude clearly reads that executive is not bound or concerned with the inhabitants of cantonments, showing as to why the Constitution of India is not applicable within these 62 cantonments in independent India. And especially maybe my Ambala cantonment, maybe the plight of government and private lands within these cantonments is nothing but servile. Government come private lands in the custody of the Ministry of Defense within any given cantonment boundary pillars, notified at various intervals during the British era, have become vulnerable to none other but the government custodians, like the politicians, the bureaucrats, even senior military officers, high end citizens. You name any of these 62 cantonments, and you will be left that in most part these cantonments are now being hijacked by these people. So what, when the Britishers left, whether the constitution given to us, whether the rule of land, or whether the policies made by the parliament since independence, or even the various Supreme Court or High Court judgments, all are kept in abeyance. None are shared with the residents. The custodians, which is the government or the executives in place now, who are becoming indirect occupants of these bungalows, are politicians, are bureaucrats, are high-end military personals. So everywhere the rule of land is missing. And in these cantonments, none other the executives, as under the aegis of the Ministry of Defense, who is made the immediate custodian of these army lands, so presumed, and further classified as A1, A2, B1, B2, B3, B4, and recently I came across B5 in Meerut cantonment, and then subsidized Class C lands. All but least the category 3 land, which your and my bungalow fell in, is usurped. These records or land records are never brought in front of the court. Why? If the government is willing to take our bungalow and wants our bungalow, they can very much do it under the Land Acquisition Act. So why do they need to harp on to the facts of that we are a Governor General grant or something like this, and compensation is only to be paid for building? Why can't they pay us for land? So now the only ray of hope is when you file a suit, or well, I keep saying that please do not become a plaintiff, but the only ray is left at the judicial end. That also, I remember when I was in a meeting with the former Chief Justice of India, who's no more, he very clearly said, Mr. Das, whatever you've been pleading has not come in front of the court. So we have to very honestly plead every minute, smallest pleading between the cantonment boundary pillars and the military boundary pillars. I have various videos on this, various sale deeds, how lease monies, whether properties in cantonments were being mortgaged. You have to understand these executives sitting in the DGD office or the PDG office or the DOs or COs, they are the unabashed sovereigns of these lands. British cantonments within so called cantonment boundary pillars, this self organizing behavior of executive, which is the DG, PD, DO, CO, has left this British cantonment land vulnerable and we residents at the mercy of the honorable courts. So, guys, we need to annex all these book pages starting from Cantonment Act 1864 to 2006, Weather Cantonment Act 1889, 1912, CLA rules in 1925, 37. We will have to bring these documents in front of the courts. How mutation, how compensation has to be made, how documents have to be kept, what are the delegated powers given to the departmental officers, how notices have to be signed. Residents would like to presume that executives may either object to the annexation of these documents or notification, plans, and other relevant materials. So this will continue. Now, where in the cantonment laws and CLA rules and MLMs it is written? Now, I will read from J.P. Mittal's book itself, which carries Cantonment Act 2006, how the volume speaks. You will be surprised in on page 5, legislation for cantonment was split into two parts. The one part was the Cantonment House Accommodation Act, and the other part was the Cantonment Act number 2 of 1924. Some people again question this. On page 8, land branch and cantonment executive officers was amalgamated in 1948. Then what before this? Very important. The Land Hiring and Disposal Services was created in World War II and wounded it up in 1957-58. This shows that Rape Act 1952 was introduced with retrospective effect of 13 years from date. Why? Just to cover this period. So we have to understand that there are 62 cantonments in independent India and all are governed by the same act. The area is approximately 2 lakh acres with a civil population maybe about 18 to 19 lakhs now. These cantonments are further divided into civil and military area, in which civil area is about 15,000 acres alone, and the executive is admitting to all these that there are civil boundary pillars and there are military boundary pillars in these cantonments. So, what is left? Now, coming to page 352, this states that land from the cantonment board be taken away and put to direct military purpose. This is not states, this is to state that lands in civil area in 1925, when no notification under section 2 of CLA rules in 1937 was made for civil area, there existed a civil area. What does the administration state? That land should be resumed from cantonment authority. Where is it stating that land be resumed from owners of the state? Now, if you read page 355, this clearly states the duties of the DO, that the executives, number 3 buildings plans under section 181 and under CLA rules 1937, GLR titles, deeds, and other proposals of amendments of making entries in GLR. Page 356, government rights are recorded in civil records. Plaintiff or we as residents would like to know what is the civil record Is this to be that record which is maintained by the district commissioner or the cantonment magistrate as per the 1924 or the 1864 to 1924 power given to the cantonment executive officer? Read page 357. This clearly reads that DO executives has to maintain the grant register of buildings. Residents would like to know and would like that the executives come clean to the Honorable Court and state that this grant register is regarding buildings alone, which is to be presumed of all those lands granted by the executives for making buildings on them under one of the Governor General order. We can understand this. Page 357. Old grant sites. It has to maintain, transfer, and even addition in building and alteration. It even mentions the page of MLM 253 to 257. So residents would like to state that executive has been stating in para 5 of its written reply. Now I'm reading a part from where a departmental executives have given a reply that plaintiff was asked to supply the building plan of the constructed authorized superstructure such that sanction plan in the so and so meeting, but plaintiff have failed to do so, which is sufficient to prove that the superstructure in existence is totally illegal and unauthorized, for which the plaintiff is not entitled for any compensation. Now, just imagine this is what the executives do, that the executives give such brazen statements, and being a subsidiary of Government of India and a sensitive ministry, executives fraudulently garner with misrepresentation and coercion and deceit to the Constitution of India, judgments and orders in their favor, which brings inequality to every citizen, even after the Constitution providing equality to the citizen of India. We as residents seek that for such written statements, strictures should be passed against the executive for wasting valuable time of the court and burdening the exchequer with financial implications. Read page 389. It clearly states that the DO executive will hold all grant paper. Then why is the Honorable Court subjudiciously passed orders that the executives don't need to do so? Likewise, the courts are not given equal playing field to both the residents and the executives. Similarly, when we read page 407, section 30 of the Army Instruction for Defense states, class 1 to be retained permanently. All documents related to old grant and so on in column 2347 stating relevant gazettes, plaintiff would want that all facts and documents be produced by the executives and the owners to prove their ownership on land, and further that how compensation has to be paid for these estates or bungalows. Page 776, mutation of old grant is stated, and it says admit all rights. This is what and how the executives have, with fraud and misrepresentation and coercion, have taken admission deeds from residents. Now, going back to the Cantonment Land Administration Rules, page 338, once again it states what documents have to be retained permanently in column 1, 2, 3, 4, 5, 7. So, friends, in these videos on my podcast, I would be sharing all laws. I will be sharing page numbers. I'll be sharing book references so that we can move to the next step of trust that yes, we guys were revenue free grants. Never ever the Britishers since 1812, 1820, or 1859 converted us into new grants. Because we were retained, we were never resumed. Our rights are proprietorship. Thank you. Good day.